Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Anderson v. Liberty Lobby. This case was heard in the Supreme Court of the United States in the year 1986. Let's go ahead and jump into the facts of the case. So the plaintiffs here are Liberty Lobby. Liberty Lobby was a nonprofit conservative think tank type of lobbying organization. The defendant is Anderson and the Investigator magazine. Liberty Lobby filed a defamation lawsuit against the Investigator magazine and Anderson because Liberty Lobby was the subject of some articles that labeled them as neo-Nazis, white supremacists, and anti-Semites. And they felt like these labels were wrong, and so they brought a defamation action against the magazine. Well, in defamation law, there is a public figure and a limited purpose public figure, and these figures are there is a higher evidentiary burden to prove defamation against one of these two figures. That higher standard is actual malice. So to recover for defamation, if you're a limited purpose public figure or a public figure, you have to prove that the defamation was published with actual malice. What actual malice means is knowledge of the statement's falsity or reckless disregard for the statement's truthfulness. Actual malice must be proved in a trial court with clear and convincing evidence. So that's the standard of proof for actual malice. Now that's important in this case. So what happened was the lawsuit was filed by Liberty Lobby, and then the two parties got into discovery. While they were in discovery, Anderson got the writer of the article, and they had the writer of the article file an affidavit, which is basically sworn under oath, written statement about the case. And in this affidavit, the writer showed that he had researched all of the statements and provided his sources. So what the defendant here is trying to say is, well, these weren't made with knowledge of the falsity because the writer actually had researched the truthfulness of these statements, and here are his sources. They provide this, and then they move for summary judgment. Summary judgment under Rule 56 allows a court to basically end an action, to adjudicate an action early on before a trial when the judge determines there's no genuine issue of material fact for the jury. So they argued, the defendants did, that, hey, we have this affidavit that proves that these statements were actually researched. And there's no way a jury could find with clear and convincing clarity that this defamation was committed with actual malice, namely because of this affidavit. So they move for summary judgment, and the district court grants it. Now the Court of Appeals reverses the district court, and they say, well, it doesn't matter that the standard for actual malice is convincing clarity. What only matters is you just have to prove beyond a preponderance of the evidence that you still have a chance with the jury to avoid dismissal on summary judgment. So key thing to note what the Court of Appeals is doing is they're saying, well, the standard for actual malice might be here, but the standard to just avoid summary judgment is lower. Now the Supreme Court reverses that, and their new rule is important because they say the standard for actual malice is here, so whatever the substantive evidentiary standard is, and then the standard for summary judgment is right here. The two are on par with one another. The substantive standard of law, that evidentiary standard, is the same at trial as it would be on summary judgment. And there's a nice line from Justice White in his opinion where he says, in ruling on the motion for summary judgment, the judge must view the evidence presented through the prism of the substantive evidentiary burden. So that means exactly what I just said, that the standard for a trial, the evidentiary burden for trial and the evidentiary burden for summary judgment are one and the same. So there's a few things to note. That's the first one. The second, and the court elaborates this in their opinion, it's not the judge's job to be the fact finder. The jury is still the fact finder. What the judge is to do is to determine whether or not there's actually a genuine issue of material fact for the jury to determine. And that is the judge's role. It's not to be the fact finder, it's just to determine whether there is a fact at issue that the jury should try and prove. Now, the third point would be you need enough evidence to meet your standard that a reasonable jury could find in favor of you. So to avoid a summary judgment motion, you need to be able to prove that a reasonable jury could find in favor of you. So you're going to need to present some evidence, right? If one party moves for summary judgment, then you, as the non-moving party, are going to need to provide some evidence as well to say, you know what, hey, there actually is a genuine issue of material fact. And you can't just point to your original pleading. The pleadings are not evidence. So you can't say, well, we pled that this is the facts, and then they're saying with their evidence that these are the facts. No, you need to actually present your evidence to show that, yeah, there is a genuine issue of material fact. Thus, this should go to a jury, Your Honor, because there's an issue that the jury needs to determine, and it's just your role to determine whether or not there's actually an issue. There's a dissent, two dissents filed, one by Justice Brennan and another by Justice Rehnquist and Justice Berger. Both argue essentially that this is putting a little bit too much power into the hands of the trial court judge. The trial court judge now has the power essentially to adjudicate without a jury involved. And they're saying this is kind of an overstep, providing this extra evidentiary burden, setting it on the same level as the evidentiary burden at trial is just too much, because it's going to give too much powers to the judges. And these judges now are not going to adjudicate consistently throughout the federal courts, because different judges will have different ideas about what a genuine issue of material fact is. So the case really shows us that there is a divide in ideas about summary judgment. One being that, yeah, it's efficient, it's speedy, it saves us judicial resources when we can get rid of cases before we even have to go to trial. Now, the other side of that would be, well, it could lead to some injustice. It could lead to some inefficiency because there's going to be a lot of appeals. It also could be a violation of the constitutional right to a trial by jury. And so there's this tension between those two ideas, and the court here seems to lean more towards the argument of efficiency and construing the federal rules in a way that allows for the speedy adjudication of matters before the court. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.